Very good afternoon to all of you. And when I say very good afternoon, this is to all the people who are physically and mentally here and the people who are physically here, but in the virtual world. A great panel here, and we are going to discuss about IBC laws and the strategy for business. But before that, thanks a lot to the BW Legal World, Dr. Anurag Batra, for providing this fantastic platform where we meet regularly and interact and discuss the ideas as well as the laws. Thanks to Dr. Bhasin also for giving us the insight. And he has been one person who has stood with various associations for the cause of the practice of lawyers in India and the legal profession. So we are all the lawyers of his era, and the lawyers who are younger to him are thankful to him because somebody needed to take that stance and he took it. Well, moving on to my session, our discussion, we have a fantastic panel here, and I'll request my panelists to introduce themselves. And I, as you know, am Alishan Naqvee. I am partner with the law firm of LexCounse Law Offices. Over to you, sir. Do you have?
Ramakrishnan. I'm a barrister and senior advocate, practice at the Supreme Court, based in Delhi.
Good morning, everyone. My name is Ameya, Gokhle. I'm a partner in the Bombay office of Shardul, Amarchand, Mangaldas. I'm primarily a litigator, litigating across most forums, and a large amount of my practice is, of course, the IBC and insolvency practice. It's great to be here today, this morning. Thank you to BW Business World for the invitation and an opportunity to put forth my views. I hope that this session will be very engaging and as informative for us as it will be for all of you all.
Good morning. I'm Hardeep, Sachdeva. I'm a senior partner at AZB and Partners, and I'm a corporate M&A lawyer, but I call myself a business lawyer more than a corporate M&A lawyer.
Hi everyone, I'm Manisha Chaudhary. I'm the managing partner at UKCA and Partners. I practice mostly corporate commercial litigation with a bit of transactional law as well.
Hi, I'm Amresh Singh. I'm a senior partner at HSA Advocates. I do real estate and disputes. Basically, my focus is that home is integral to everybody. That's a very emotional and sensitive aspect. And, how does a home buyer get affected under various regimes? Notably the IBC is what is very, very relevant today.
Thanks a lot. Thank you very much, dear panelists. And just as a refresher, we will be discussing, as you see, we have a very varied experience among us on the panel. Just as a refresher, the Insolvency and Bankruptcy Code came into being in 2016, then got implemented. It brought in within the recommendation of Bankruptcy Law Reforms Committee, which provided that the businesses should be permitted not only to succeed but also to fail, and fail honorably. That was the first parameter. Second also was that the rehabilitation of the companies was required, because in the earlier regime of Companies Act, you had an option. If there is a default, then there was a winding up. So what it introduced is a new concept in India, which was CIRP, Corporate Insolvency Resolution Process, within which the company would be put up, and along with the creditors list and all those being made, if the company is suited for anybody else's business needs, they can bid and take the company. So the company continues, the economic activity continues, and the employment continues, which is in the interest of the economy itself and in the interest of the nation. It also brought in a few new concepts like resolution professionals. Earlier, anybody could be a liquidator, and liquidation was the only option in case of defaulting companies. Now we have resolution professionals who are qualified, who have to undergo an examination with the Insolvency and Bankruptcy Board of India, and then they qualify and they take charge with the support of the suspended board of directors if the corporate insolvency resolution process commences. And they run the company till the time either somebody takes it over through a process and with the approval of NCLT, or it goes into liquidation, then also the proceeds follow. So a few new things this brought in. The law brought in, of course, as every new law, it had very good intentions. It faced certain roadblocks, which came both from the interpretation of law, from the practicality of implementing, from lack of infrastructure, and also shortage of members, which we still face. Some of these aspects we will cover in the discussions. Before I move on with the questions, some of these statistics, which I want to share, and this is as per the IBBI report, which is published annually. And this year's IBBI report, which is published in March of this year, says that till March of 2023, total of 6,571 CRPs have commenced. From the inception, when it came into operation, people filed applications, and you file an application earlier, it was for, again, just to give a background, if the default was more than 1 lakh rupee, which was just around the time of Corona raised to 1 crore rupee, you could file an application, and if the NCLT found it to be meeting with the criteria, then CIRP would commence, corporate insolvency resolution process would commence. Till March 2023, 6,571 CIRPs commenced, out of which 4,515 have been closed, means they have reached some result, whereas 2,000 cases are still pending, 2,056 cases roughly. Now, out of these 4,515 CIRPs, 2,030 have gone into liquidation, which is 45% of the total number of the CIRPs which commenced. 45% went into liquidation. So it is the same as the previous Companies Act, CIRP period notwithstanding, they went into liquidation. 848 was withdrawn or settled, which is again 19%. So when somebody has a default, you file a case, the person settles, doesn't want to go to CIRP, that is a 19%. 959 closed on appeal or review or settled, which means CIRP admitted, somebody appealed, either the decision was reversed, or it was settled, or it was sent back to NCLT for reconsideration. Out of that, 678 now have approved resolution plan, which is a percentage of 15%, 1-5. So out of 100 cases instituted, only 15 saw closure of CIRP successfully within the objectives of IBC. That is one way of looking at it, and we'll discuss that. Just a piece of data. The IBC also came in with a legislation which has strict timelines. Of course, the courts interpreted that the timelines are mandatory for the applicants and the companies, corporate debtors, but discretionary for the tribunals and the judges. Now, 73% of these CIRPs take more than 180 days. And this is the collective data of all these years. CIRP ideally should finish within 180 days, extendable to 270 days, and in certain cases to 330 days. The idea of IBC was to shorten the time period. 73% now take more than 180 days, and 64% more than 270 days. Now with that data, I move on to my panelists. And first question is to Mr. Ramakrishnan. Sir, thanks for being here. And as a senior advocate, I wanted to start with you. You have, sir, seen the time of winding up company courts in the high courts and the IBC, I understand. What broadly do you see from a bird's eye perspective has changed over these years? What have we achieved? And how do you think the two eras are different or they are similar?
There's progress in the right direction. Now, let's talk of two objectives of IBC as per the statement of objects and reasons. One is timeliness, and second is maximum realization of value. If you start with timeliness, the timelines under the 1956 Act, the triggering of the liquidation process used to take about 2 to 3 years. File a petition, notice ordered, adjournment, and these were additional difficulties in the non-metropolitan courts, the chartered high courts. You go to the others. Some of these high courts, the total number of company petitions filed in a year was 5. So when you go there to argue a company petition, you start off the Bare Act saying, please look at this is the Companies Act, and then you start from there. Those challenges are now. Now when you talk of triggering the CIRP process, we are in a matter of months. Then the second, the end process. The statistics that you said are concerning, but are of concern. But when you look at the liquidation process under the 1956 Act, we measured by the calendar, not a single year's calendar, 10-year calendars together. Liquidation process, minimum 10 years, 15 years. So we are in the right direction. But a lot of things to do. Lot of improvement to be made, but the direction is right. This is on timelines. Then you go on to realization of value, maximization of value. Sale of property, company property. By the time the liquidator went over to get the permission for sale, property, all the machinery, everything, stocks, everything would have been junk. Right. The only place where value was realized was real estate. There you had huge value because the process took 20 years. So both ways, I think this is a step in the right direction.
Yes, I agree. The concept of it being given away as a going concern and being kept as a going concern is a vital thing. My next question related to this is to Ameya. What happened when the new law came in? 1 lakh rupee was the threshold. And unlike the Companies Act, you did not have to prove the solvency of the company, you only had to prove debt and default. Now, I remember an instance when I was in a court, and it was before NCLT, and there was this guy who filed for his clients, the lawyer who filed for his clients a case where the default was 1,05,000 rupees. So the judges looked at him, the tribunal members looked at him and said that you have filed this case for 1,05,000 rupees. He said yes, and audaciously. They said, but haven't you advised your client? He said, yes, I advised. So what did you advise? That you need for IBC, you need 3 things. Debt, more than 1 lakh, default, and application should be complete. And he's perfectly right. And the members looked at one another. Thankfully, they raised the limit. But I think a lot of lawyers had a very good time sending notices for their clients on all the defaults when they were above 1 lakh rupees. Thankfully, that changed. Ameya, my question to you is that when you go through the realization schedule and you see what Mr. Ramakrishnan also said, maximization of assets is there, but the secured creditor, unsecured creditor, operational creditor, financial creditor, we'll touch those aspects. How do companies now decide as to when to trigger IBC against any of their debtors? And whether at the end of the tunnel they will have anything, it's just a pressure tactic to send a notice and then see if they are operational creditor, or to just file a petition and see for settlement? Do they understand the procedures?
Honestly, in today's time and age, even the threshold limit of 1 crore is very less, yes, frankly. With businesses becoming really big, 1 crore is really a small amount. And partly because the threshold is so small, earlier of course it was 1 lakh, now it's 1 crore. We find that clients tend to be very trigger happy. It's a cliche, so as to say that insolvency is not a recovery mechanism. And a lot of clients forget that, or as you rightly put it, a lot of clients feel it could be a pressure tactic. Personally, I feel it's a very wrong way to start off on both counts, because frankly, I mean, ultimately, even if you do recover your money from this process, the cost-benefit analysis is really something that the clients need to look at. Now, look at the case of, say, a financial creditor, and look at the case of an operational creditor. An operational creditor in a company which has number of services, but has an outstanding which is more than 1 crore, may end up getting an admission. But what is he achieving at the end of the day? He is last in the food chain. He's perhaps not going to be getting a single rupee. Most plans, as you're aware, don't have provisions or don't have large provisions for operational creditors. He's going to end up spending time, money, costs. He's going to end up spending the initial costs of the CIRP, because now courts have started awarding the initial costs of the CIRP to the applicant. They have to bear those costs. So ultimately, after a 4 or 5 year process, he has nothing but ego, really, in that sense, that he's earned, but nothing really in the pocket. So a lot of clients need to really evaluate where they stand in the food chain before really deciding or before really opting to invoke provisions of Section 7 or Section 9 of the CRP, of the IBC. I don't find a lot of clients do that. And then somewhere down the line, when the applications are pending or applications are admitted, clients lose interest, and the process is irreversible. So a company which would have been able to perfectly repay an amount owed to your client in a regular litigation process, in a regular recovery process, now is stuck with this entire insolvency process and nothing is achieved out of it. So really, I think clients need to be conscious of what they're trying to achieve and whether they're really interested in looking at getting their money back or whether it's just a mechanical process that they're following. And I truly believe that IBC is not a process that is to be followed for just the mechanics. It's really a process where consciously all stakeholders need to be aware that there's a company, and if the company can be revived, I think IBC should be your resort only as your last resort if a company is really revivable, and not just out of not just as a matter of ego or not just as a recovery proceeding.
Thanks a lot. Thanks, Ameya, for that. In fact, I am privy to some of the instances where the operational creditors filed their applications and the petition got admitted. In the earlier time, even now, 1 crore rupee, as you say, is very less. And then the RP is appointed and they have to pay the RP. And then they realize that they have committed a mistake because the bill of RP may be more than the amount of recovery that they had to make, even the amount of claim. Recovery is a small thing. Coming back to Mr. Ramakrishnan, to you. Now, there are companies at an exposure. You may have debtors. You may not raise dispute all the time. And so what can the debtors do if they have, what can they do if they have creditors more than 1 crore rupee? Can there be some strategies wherein they can avoid IBC? I agree with Ameya, it should be the last of the priority for the persons who are invoking IBC, but as a debtor, you still need to protect yourself. Well, any functional company will have creditors, and they are likely to be above 1 crore rupee.
Starting from where he had left, let's say there's a trigger happy creditor coming over. 3 things, as legal counsel or advisors to a debtor firm, 3 things you need to remember. 1 is liquidity, 2nd is solvency, and the 3rd is valuation. Insolvency, IBC is all about liquidity. You might have a great solvency, valuation may be good, but liquidity is all that matters. And there is the disconnect. If you have a petition against you, the strategy is to first find out who's the creditor. If it's a financial creditor, that's like James Bond with a gun. Don't fight him. You're bound to be killed. Now, if you have something against coming from a financial creditor, your best strategy is to raise the money, make sure the default doesn't happen, or settle when it comes. If it's against an operational creditor filing against you, that's more like Inspector Clouseau. Chances are great, in a Pink Panther you might win. There, your strategy would be, if you have a liquidity crisis, you will use the money from the operational creditor to pay your financial creditor and keep yourself alive. How do you do that? You do that by not paying your operational creditor. If you have some event coming on, payment is due to your operational creditor, you raise a dispute. You raise a dispute for the heck of it. File an arbitration notice, appoint your arbitrator, file a civil suit. Doesn't matter if it's going to be dismissed. It will be dismissed after a couple of years. You have that breathing space for 2 years, and then you take it on. That's the way you handle liquidity. But then, these are events that you must anticipate right from the beginning. You can't come there a week before and then expect to handle this. I think there, what Dr. Batra said, that the legal counsel and the law firms must be more integrated with the business to make these strategies work.
Thanks a lot, sir, for that insight. Now, related to that also, when we talk about from both the sides, from the creditors and from the lenders, my next question is to Hardeep. Lenders, usually you have various options. You had earlier to IBC also, you had Safasi, you had other options. Today, from the perspective of the lenders, if we were to understand for the debtors or generally as a lawyers also, from the perspective of the lenders, what are the criteria which make them decide whether to go for IBC or for any alternative option? They may have arbitration also, they still have recovery proceedings, they have Safasi. How do they decide?
Yeah, thank you. So, if we see this whole law from the perspective of the financial institutions, see, end of the day, this law was promulgated keeping in mind, amongst others, the interest of the secured financial creditors. If we look at the financial creditors, means those financial institutions like banks or any other financial institution which is lending money to the corporate world, if we still look at their apathy under IBC, then I must say that it's a dream too far to come true till now. If you look at your data once again and just answer a simple question as to how long will it take for a financial institution, including a bank in India, to get your insolvency petition admitted, it is not going to be less than 6 months. It can easily take you 12 months.
Yes.
And between 6 to 12 months, a financial institution which has lent money to that errant borrower who is not paying, and to the corporate guarantor or to the personal guarantor who are not even aligning to the servicing of interest or even holding the security tight for the benefit of the financial institution, you will have to explore other options which are available to you as financial institution or financial creditor. So what happens is, as people like us who are business lawyers, even before you lend the money as a financial institution, that question is usually asked to you: what should be your strategy in this lending transaction here? Are we dependent on IBC to get the money back? I agree, it's a cliche that IBC is not the tool to recover money, not the tool to seek enforcement of your security, but the question is always asked back to the business lawyers or the corporate lawyers that, is this your first strategy to get the money back? That can't be the case. That can't be your answer, because you know fully well it will take you more than 6 to 12 months, and I'm sure very soon Amresh will tell you, if you have money lent to real estate sector which has 5,000, 2,000 home buyers, you can forget about your admission of your insolvency, and then of course the different nuisance will come into play.
Correct.
Therefore, we have to find out the other options which are available to the financial institution as part of the strategy when you are lending the money. And the choice is again dependent on what are your securities. If you are that secured financial creditor where you have security of a real estate asset or a land or a building, okay, where you do not have third-party rights created like a real estate development asset, then your first choice to seek an enforcement of your security could be SARFACI. Why SARFACI? Because the moment you give a SARFACI notice to the borrower is bound not to deal with the asset. Means without going to the court, which could have been the case for you to seek a stay against a disposition of asset against a borrower. In SARFACI, the moment notice is issued, asset is not to be disposed of. There's a law here. You might have that choice better available with you when you are planning to make a lending to any borrower here. But sometimes that may not be the choice that you have. Sometimes you may have multiple lenders involved in a single borrower or to a group of companies here. You might only have a choice to go back to IBC and be at the mercy of the NCLT to grant you admission of your petition and or let you be in the queue there. And at the same time, when you make a decision here, we always do a calculation. If push come to shove, if we are amongst many lenders in a company, what would be my threshold percentage if I happen to be sitting on the COC here? You always want to cross that magic number of 35%, if not, let's say, in a supermajority. Why? So that even if you can't drive the whole process of insolvency, you can at least not let something happen which is so prejudicial to your interest.
You can block some things.
Yeah, you can still block something which is not the best way, but yes, still a tool to make sure that you're not, getting deprived of what you should be getting here. You still have the tools of, recovery suits. Why would you take recovery suit, in some situations in recovery suits, when you have to pay such high court fees,
yes.
The court processes can take 5, 10, 15, 20 years. I mean, all said and done, the data or the recovery data or the time efficiency data of IBC will be far better than the similar data for the civil suits. Civil suits in this country are still 5, 10, 15, 20 years, or maybe
Absolutely.
more. It doesn't matter. But end of the day, in the court procedures or in the civil suits as well, one can file for interim interlocutory orders, which are so quick to come in our country. which I'm sure sir will speak here. They are the fastest orders one can get is getting interim stay, getting interlocutory order against not to dispose of something, getting order for a declaration of suit, which are far cost efficient, and you can get that. Therefore, you still have that choice there. The choice needs to be made, in my view, especially for people like us, at the time when you are doing that transaction here first, so that your strategy is clear as to which way you will go. And then choice will have to be made when the time has come for you to make the choice,
Thanks a lot. Thanks a lot, Hardeep. That was really insightful. In fact, as you referred real estate sector, I think it's time to move to Amresh and ask him, how is IBC working out for the real estate sector from the perspective of, not from the home buyers, but generally for the developers and the resolution applicants? It's a complex,
very
it's a complex domain.
Yeah, very interesting question and very relevant also.
Yeah.
You see, what is happening now is that there have been various judgments which have kind of defined the interplay between IBC, RERA, and the consumer disputes redressal forums and all of that. But, obviously predominance has been given to IBC as a method which the home buyers have to really initiate so as to get their, grievances redressed. Now, I will talk with examples. Let's look at some of the important insolvency proceedings which are going against the developers. They have clearly been going on for a very, very long time, and that does not really help the situation. There are certain insolvencies which have gone well beyond 5 years. I have personally been involved in some of the matters. So in one case, when the claim has been admitted, there has been a stay granted by NCLAT, and that took 4 months to vacate the stay, and for the NCLAT proceedings to commence and continue. So that definitely is not going to be in accordance with the time prescribed under the law. Yes, it has been made directory, but the delay has got to be reasonable. It cannot be going on for 5 years and 6 years and so on. We look at the JP insolvency. There's no conclusion in sight.
Never.
So, these problems are always there. We do have home buyers who are financial creditors. But the real hope that I see is that the home buyers resorting to IBC is till the time it is all related to projects which have been done in the past in the pre-RERA regime.
Yeah.
Moment we come under the RERA regime, then there are safeguards which are built, notwithstanding all the criticisms that we can level against RERA for non-implementation, slowness, and so on and so forth. The fact remains that there are well-regimented procedures prescribed under RERA, like how you deposit the amount. 70% has to be in a separate account. That amount is to go into the cost of land and cost of construction, and so that, and well-defined timelines with corresponding penalties and so on and so forth. It's going to tantamount to all the developers which are not defaulters to stay in the picture. As Supreme Court rightly said, that the good time of the defaulters are now gone, and the economy is on its right path. So with regard to the IBC. So therefore, and with all these, some of the novel items being introduced, such as the reversed insolvency or project-wise insolvency, the incorporation of home buyers as a financial creditor, so on and so forth, and regular amendments which are going to happen by the regulator and all that, we could look into a positive direction, but the fact remains that IBC has to work in conjunction with RERA.
Yeah, that's true. In fact, RERA perhaps is a very good step, though I think, like the NCLT tribunals, RERA also has some challenges. But moving on to Manisha. Manisha, out of the so many apartments that you have booked over the years as a home buyer, how many have been delivered and how many have not been? And what are you doing about it?
I think when it comes to the home buyers, more or less they have the right under the IBC in Section 7 to come before the NCLT and get their rights triggered and have it done. But what is happening in some of them is that there is no resolution in sight at all. Only because that process is not put into the IB code yet. One of them is the reverse mechanism, which which has been discussed. In reverse mechanism has no place in the IB code at all.
Correct.
However, it is needed in the IB code. There are real estate projects where certain projects are already done. There are towers which are just lands. There are half-built towers as well. And all of that cannot be done in one process.
Correct.
It's impossible for home buyers to sit on a COC and see eye to eye on such a situation. And that is where I believe the IBC is failing them. And I believe that it is already in discussion now and an amendment is coming through for that. So hopefully they'll be able to recognize that loophole and sort of club that there. Another issue that home buyers are facing, in my opinion, are whether they're secured or unsecured creditors. And that itself is a topic of discussion in many of the cases before the NCLT as well. But till date, there is no solid ground on whether they are secured or unsecured. In my very humble opinion, it is a secured debt, but then in the books it's not treated as such. So if it's not treated in the books as such, who am I to say that they're secured? So from a very pragmatic view, yeah, they are secured, but from a very technical financial view, they're not. So that is what I believe needs to be discussed in the IB code and soon to be plugged in right there.
It's very interesting under the IBC code, Manisha, as the criteria changes from operational creditor, financial creditor to secured and then unsecured creditor. And at different stages, different things become relevant. Again, touching with you, another aspect of IBC from the point of view of resolution applicants. Now, a lot of companies which have defaulted are under the CARP process. We also know that there is a whole industry out there which manages the acquisition of these companies for good purposes, mostly. Do you think that IBC is also working in parallel as a good acquisition strategy for the businesses who are viable and with respect to their competitors, with respect to other companies in the same sector which are in distress? Right. Or for diversification? Right,
Alishan, I really do think that IBC can be a great acquisition takeover sort of a mechanism to be taken care of. In terms of acquisitions, there are companies, and we've seen it in the top 10, 12, which have been resolved, that it is sort of a merger of the big entities or takeover by the big entities. Say, for example, SR being taken over by ArcelorMittal. Ruchi Soya, for its own sector, FMCG was taken over by Patanjali. Yes. We have to see how JET goes. What is right now happening in JET, I mean, it's taken over, but not yet a resolution being put into place. And same with Go Air. I do think that it's a great tool for acquisitions. You wait till your competitor goes into IB code, or you might even sort of induce certain things and play your corporate espionage, or however you want to say it in a nicer way. But these things are tools that have to be used. It helps you acquire assets at a much lower rate. There is much favorable valuations. Your balance sheet comes out better. The amount that you spend or would have idly spent in an acquisition is drastically reduced. Banks give you much favorable rate of interests and how they would like you to pay, and that helps you in your liquidity and in your cost optimization and all of those things as well. And the biggest is absolutely sometimes annihilating your competition. Take over as much as you can during the IB code. Of course, you need the Competition Commission's approval on it, but those are not approvals which I believe can be held back when you're in the IB code. So as a mechanism for acquisition, as a business strategy, IB code and looking into companies who are in IB code could be the best mechanism for bigger entities to take over. We have to keep competition in mind at all times for the general public as well, but that's something which the government has anyways looked into. Introducing that section into the IB code to say that the CCI approval is needed is also sort of diluted by the appellate and by the NCLT themselves in their judgments, that you have the time, if it's okay, if you can get it done, let them give it to you, things like that. So yeah, I think it's something that businesses should actively look into, apart from the fact that ARCs are obviously sharks out there looking for this, but businesses themselves are also now looking for, if nothing else, just land, if nothing else, plant and machinery, if nothing else, technology, R&D, killing competition, things like that. I mean, just a strategic decision that let's look into this company and see what we can do best. So yeah, I think it's a great tool.
I just want to add one thing, is that maybe two things. One is that not just the companies under insolvency have been bought by large corporates. We all know about, the big cement or steel and all those plants which are, bought by big boys. We have been able to buy the companies under liquidation. Companies under liquidations means a company which started the CIRP process, failed, started liquidation, bid started.
Yes.
We have been able to buy companies under liquidation on a going concern basis.
Because
We got a landmark judgment of selling
That's
biotech,
not
which we
provided.
advise the bidder.
No.
We have actually bought
preferences to keep it as a going concern. Even
yeah,
during
and
liquidation.
it was a challenging thing for us also to make NCLT agree to this concept here, which was missing from the rule book, to let the liquidation companies under liquidation be also bought on going concern basis.
Going concern basis. Yes.
So that has actually changed the paradigm, means that the companies which failed the CIRP got a second life, eventually got second life.
Correct.
And we bought not one, we bought two companies, two judgments, which are truly the jurisprudence on this matter, That's one part. So of course the role of M&A or role of corporates to buy these companies will not end for so long as the company is there. So even for the data of the companies which are going under liquidation, they are, in my view, not yet dead. They have a second life available if they have something available in them. Some value has to be there, And the companies that I'm speaking about are the one which were bought for their manufacturing plants, for their business which are still going on. I mean, Sterling Biotech was a big business here, and one of our client bought it. It's all public knowledge. The client bought it, and because of the plant which was still in existence, and then Provoke Retail, which was again, bought recently because of the brands that they had here by not somebody else. That's one part of it, which means that, you still have some life left there. Second, I think there is a big anomaly when we speak about secured creditors versus unsecured creditors, especially in terms of, let's say, home buyers. So if you look at the way the law is written, a secured creditor is somebody who has security over or a security given for its loan. That's what you call secured creditor. Even if I have given a loan of 100 rupees and I got a security of 1 rupee from the company, I'm a secured creditor. I think there I have all the apathy for all the home buyers who actually have a right on the asset of the company and not classified as a secured financial creditors. How can they not be when somebody who has even 1% of his loan value given as security is classified as secured financial creditor? Somebody who has his 100% of the loan fully covered by the asset of the company is not classified as a secure financial creditor.
Correct.
I mean, anomalies are endless, but yeah.
Yeah, I mean, in fact, in the RERA itself, it says that there no mortgage can be created on such an asset, and if created, it should not be dealt with, making the home buyers a secured, and I think much secured than anybody else when it comes to these entities, real estate entities. But then here we are.
As we see, there are.
Just to add to this, sorry to intervene. Just to add to this, even decree holders, financial this thing.
Correct.
Now they are placed under other creditors. So they are neither secured nor unsecured.
Not secured, they are other
but they are
creditors.
other creditors, and that's the anomalous situation because there are decree holders, and at the time of determination of the claim by the IRP, they are already suffering haircuts at that very instance.
Decree holder is
That's
somebody
the
we all know
predicament.
who can
That's
attach the
predicament.
assets.
Correct.
Yeah.
There are various interpretations, possibilities. I remember during the early days, one of the seniors jokingly mentioned that why IBC has come. I said, why? He said, it is to legitimate the write-offs by the bank, because earlier than IBC, write-offs would happen and then there would be a CBI inquiry. So we have seen various things happening. New interpretations will come in and improve. Amresh, I have one question from you, Amresh. Is that we talked about projects. Manisha also mentioned that some of the projects are half-built, and I have seen home buyers come to us for advice sometimes, wherein they actually want to avoid other home buyers from approaching the NCLT, because they know that we have a hope with this real estate builder of completing the project. If you go to NCLT, nothing will happen. Now, not only related to home buyers, but generally, do you see deterioration of assets during the SARP process?
Absolutely.
Is a serious concern?
No, absolutely. That's a very serious concern because, these structures which are unbuilt and they have not been fabricated and things like that, they would always suffer deterioration in quality. And, we have seen instances where, floors have caved in. There is general deterioration. Institute of Engineers have filed reports saying that there is a deterioration in the quality and so on and so forth. I agree with you. The home buyers are caught in that crossfire and quagmire that as to where exactly they should go. They go to the National Commission, they get a decree, the decree cannot be enforced for various complexities. In one instance, the collector could not recover it as arrears of land revenue because the property belonged to the Maharashtra government, MADA. So, when you face with those complications where the builder does not have ownership rights, then what do you recover? So therefore, that's why I again reiterate and come back to that point that IBC, if it can work along in a symbiotic relationship with RERA, it's really going to help the cause of the home buyers. And it is very, very important that the timely constructions of projects have to be attained. We cannot get caught in the quagmire of these litigations and let the structures just stand there, get deteriorated by rain, water, erosion, and so on and so forth.
Correct. And do you think, Hardeep, on that point, that RPs, who are supported by the suspended board of directors now, are they discharging their duties? We have had instances wherein we have got complaints against RPs, EOW complaints against RPs, all kind of allegations, complaints to IBBI, actions have been taken against RPs. Do you think broadly, not each and every IP like saying that all lawyers are good or all lawyers are bad, do you think this RP whole ecosystem is doing what it needs?
First, I hope that there is no RP sitting here.
Even if they are sitting, it's okay.
I don't want eggs and tomatoes to come
We
to us
lawyers
now.
criticize lawyers all the time in front of other lawyers and the
I
judges
fully
also.
agree
It's fine.
Fully agree with you. So if you ask me, it is still glass half empty. I mean, only, it may be a little political answer, but yes, end of the day, only half of them are doing their job seriously. And those half who are doing the job seriously, and I must say that their fees is enormous. I don't know if you've seen the latest fee schedules which are given. The fees is linked to a percentile of the amount recovered in the insolvency. Whereas, if you look at the statement of object, we need to always, keep that in mind, that IBC is not supposed to be your recovery action.
Yes.
Nonetheless, your RPs, who are supposed to be custodian of your resurrecting the company from being, insolvent, they are saying that if you recover money, you have to pay me X percentage of the total recovery, which is made by all financial creditors put together, as of now. So yeah, I think somewhere, we need to marry this whole thing, align it. Also, somewhere we need to keep in mind the statement of objects, which I think has a reason, which may not have been followed, in that true spirit. And therefore, I think there is a room for a huge paradigm change in RPs, Try and get some more regulations for them. Try and some more, maybe self-regulated norms needs to be there in place as to how they should be conducting, these companies here.
Correct. Thanks a lot, Hardeep. We have little time left, so I'll be moving a little faster, but Ameya, broad question from you, from your experience of seeing how the tribunals work, the timelines, etc. And we see multiplicity of applications. We have seen the judges also, the members also expressing their displeasure, because every time the hearing comes up in a complex multi-party NCLT case, there are new applications which they must hear before they get into the matter, and then the time goes away. We have members sitting in different benches. What is it that is required to be done? Because clearly the CRP timelines which I narrated earlier are not acceptable. There is a deterioration of assets. What is it that we need to do? Because ultimately this law has many benefits, as we see, broadly.
So let me start with an anecdote. Among the first dirty dozen companies mentioned SR, when this concept of timelines being just directory was not there.
Yeah.
You know, there were multiple parties in court, and multiple parties were making multiple submissions. But the judge kept telling us that, look, whatever I have to do in 14 days. So let's hurry up this process. Whatever submissions are to be made, I have to decide this matter in 14 days. He was very clear about it. And he did it. I mean, if you see the admission order, it's among the quickest that you will find now in hindsight, as far as the dirty dozen is concerned. So, therefore, looking at, you know, these directory timelines from the perspective that whatever you have to do in 330 days.
Yes.
And really work backwards from there will help. You know, everyone needs to plan from that perspective that 330 days is the maximum time limit that you have, and everything has to be planned backwards from there. Now, frankly, that's easier said than done, because the buck doesn't really stop only with the tribunals.
Correct.
I genuinely believe that this legislation is a very well-meaning legislation on paper, but a lot needs to be done in order to monitor how it is really functioning. So the stakeholders, you know, the major stakeholders in how this functions are, one, the tribunal, the RP on the other side, the RP firms that are backing the RP and sort of, you know, helping the RP in the larger mandates. There is nothing institutional about monitoring these stakeholders, because the minute the performance is monitored, the minute you know, people are held accountable, and I'm not just saying this from the point of view of tribunals, Hardeep mentioned even the RPs. I genuinely feel that there will be enough incentive for this process to be sped up, and then, you know, the sort of, you know, the end result that you're looking at today, where there is deterioration of company assets, where matters are not getting decided, where resolution plans are not getting approved for 2 years, you know, where resolution applicants then become jittery as to what they're really going to get after their plan is approved versus what they had bid for 2 years ago. There's a marked difference between the two. There's a marked difference in quality, there's a marked difference in value of that asset. So once you have tightened the processes, and a lot needs to be done. It's very simple for someone to put it that way, but a lot needs to be done at the institutional level. Once we are able to achieve that, I think we will be able to take care of what's really going on and, you know, these sort of negative results that we are getting today from the IBC process. So it's really a reverse mechanism. I mean, there are a lot of problems that you can't deal with as of now, and pinning the blame on just tribunals and timelines is, I think, being a little unfair.
Correct. No, completely agree. Completely agree. The reverse mechanism has to be there, and once the mindset is there, 330 days is the maximum time, including litigation. I think that will lead to results. That brings me to another aspect, Manisha. This question is to you. We have data points, the statistics that I read, around successful CIRPs. That's 15%. And of course, out of those successful, also some would have gone in appeal. Maybe stay is rare, but still, some directions would have been passed. Is CIRP, considering the aspects that we have discussed of acquisitions, of, you know, various benefits, benefits to home buyers, it being read in conjunction with RERA, is the data point of CIRP, successful CIRP, so relevant? Because 15% may be disappointing, but is this 15% to be seen disjoint from the IBC and the objective? And still we can conclude that IPC largely is a success, and this 15% is not a crucial data point.
Right, Alishan, I have mixed views on that. One being that I think 15% is brilliant, seeing how a CIRP is conducted. 15% is also brilliant considering who sits on the COC. And 15% is brilliant considering that I do not believe that the COC has commercial wisdom. I genuinely believe that the way the process is being done in India is not comparative to anywhere else. And it's not really functioning the way we want it to. There are massive improvements which are needed in the process itself. You may admit the CIRP within 14 days, but I highly doubt that the kind of people sitting on the COC trying to resolve a company, they do not have the mechanism or the bandwidth or even the approvals to do what they need to do on the COC. Coming to that, in a discussion between RPs, which I was part of, they very categorically and very candidly have said that the banks have now come to the COC with the mindset of saying, send this company into liquidation, it's much easier for us. So hence a CRP will not be successful if you sit on the COC with that mindset.
Correct.
And hence I see 15% as very good. Now whether that 15% is relevant or irrelevant, in my humble opinion, like I said, it is, because that 15% as against what all is going on is a good number. But CIRP being what it is, it needs massive improvements. It needs to come to a 50%, 60%, 70% success rate, so that the amount which is involved of the banks, which is an amount of the general public, has to be recovered. It can't be that 83% haircuts are being given as per the reports and only 17% is being recovered. That is ridiculous when it comes to thinking that so much public money is being involved and not being taken care of. So I believe in an all essence thing, it needs to increase its processes, the way it is conducted. It needs definite improvements. But then CRP itself as a tool is great because it provides a lot of, lot of safeguards to those who are inside it and those who are trying to acquire. So yeah, it needs improvement for sure. Like I said, I have mixed views. But my views are more based on who's conducting the CIRP and how it is done. Better laws, RPs being given more power, but restricted power. They can't go blind with power. Like with great responsibility, great power comes great responsibilities, yes, kind of a thing. They need more, a guideline of how they work, especially their ethics. The ethics in the RPs has really to be discussed as to how they're conducting themselves. And I say it with humility that there are lawyers who are RPs and RPs who are lawyers just working on different cases just like that. And that's not how a professional should be working, either a lawyer or an RP. So those things have to be looked into. But nonetheless, it's an evolving law. I think it'll take another 3, 4, 5 years for us to get there, to get to the international level of it. But
Correct.
Slow and steady.
Thanks, Manisha. Amresh, I'll come to you. Though you mentioned that both of the RERA and IBC can work in conjunction. In your experience, because home buyers is usually crucial, a lot of us also, maybe perturbed home buyers. Do you think that the exits which are being given is also a result of IBC process? Because sometimes we hear that the home buyers can surrender the homes, take the return, go away. I mean, is it that the developers have a fear of IBC, if not RERA, and therefore the home buyers, if they don't get a house ultimately, they get a refund or they get an exit or some property in alternative project of the home buyer? Do you see there is an ancillary benefit, a fringe benefit of this whole process for the home buyer somewhere?
See, I think, developers today are more fearful of RERA, because RERA kind of gets triggered moment, they register a project.
Yes.
And once they register a project, there are a string of compliances which they have to comply with, including financial deposits and so on and so forth.
The RERA account and
they come on the wrong side of law so far as IBC is concerned once they are branded or declared as defaulters, and that's when their paradise is lost. They are ousted from the management of the company and they sit outside and watch the proceedings. Now, as historically the evolution has taken place, we know where some of the promoters are, and they're all some of them are in jails and so on and so forth, facing a whole lot of prosecutions and so forth. And that's why that interplay is very, very important, that, RERA. So, as I said, that with the kind of safety mechanisms RERA is built for the home buyers, it will be a foregone conclusion in future that a lot of these real estate companies would actually be going to IBC, because RERA, suitably empowered, would have those powers of oust the defaulting developers and replace them, But of course, for that we need to strengthen the RERA. For that we need active home buyers, and so that, those positions are not attained, because, the people at large have experienced this. that 333 or 330 days is not making any sense today. You know, these are all spreading and stretching out 2 years beyond 5 and 6 and 7 years, and so on. Now, why RERA is also very, very important. I was doing one of the matters where the audit clearly said that there are no straight lines in the building. Now, that is, you know, you can do all kinds of solutions, but at the end of the day, you're not going to be dismantling those huge, you know, buildings. But with RERA active and with all those criticisms being levied under the, you know, statutory bodies under which these developments are taking place, you know, these things are not going to happen in future. So as I said, the future looks brighter. It's just that all the projects which are pre-RERA times, you know, are suffering this infirmity today. So therefore, we need to focus, and those things are already in the pipeline, to strengthen RERA so that they work in symbiotic relationship with IBC to make the life of home buyers easy.
At least going forward, we will see better times.
Yes.
Okay. Hardeep, I keep coming to you with sensitive issues. Another one for you. I do believe that retirement age has a purpose. And now, do you think that the tribunals, not only NCLT and CLAT, the tribunals do suffer somehow because of the judicial members being retired? You know, it's experience versus energy. And it's a sensitive issue, and I've kept it for you, purposefully. I'm joking.
I'm okay, I'm absolutely fine, you know. But tell you two things. I think we all know that, and there cannot be any disagreement on the fact that our NCLTs across the country are flooded. They're just so flooded with these IBC petitions, cross applications, and, you know, all sort of IBC work here. So they are overworked, overburdened, whatever you may want to call it, you know. And therefore, there are humongous delays in getting the smallest thing done here. Delays are also on account of, let's say, the delay in the natural justice sort of a system where when you file an application, somebody will file a response, there has to be a rejoinder, time given for arguments, you know, one day, one lawyer not there, second day, second lawyer not there, or judge not there, or, you know, some vacation happens. Beyond that, the dates are not given on time because they have excessive amount of work here. I mean, that I think is certainly because of two reasons. There should be some conviction on every member. Conviction means that a statutory code of conduct that you will have to pass an order within n number of days.
N number of days.
I mean, we ourselves are privy to situations where orders were reserved and not passed by NCLT for six months.
Yes.
And then the member retired.
Yes.
The member retired, and what are you supposed to do? You spent your 2 years, get the whole process in place here, order got reserved, and the member retired here. I think those things should be seen and should be taken very strictly, you know. Until we have the conviction given to a judge as well, I do not think they'll keep passing the orders the way it should have been passed here. Although in the recent past, Chief Justice of India has been voicing very clearly to all the lower judiciary and all the high courts to ensure that they're passing their orders within certain number of days here. Now, having said that, one of course, you know, that's one part of it. Second, I do believe that that NCLT cannot be a forum for retired members, you know. Like if you today, I think I was talking to, you know, sir only, you know, he also teaches judges, you know, he's a teacher of judges. And I was telling how there is a young blood in the high courts which has reached there.
Correct.
We need to get the same thing somehow, or maybe we need to have these young lawyers who should be aspire to become the, you know, members at NCLT here. Get that young talent to these tribunals to ensure that you are getting both speed and, in my view, efficient system in place here.
Yeah.
I'm not judging on the quality of, you know, each member here, but yes, in terms of efficiency, we need to get some more young members into this, you know, forum here.
No, I agree. Sometimes they also have to do because of, see, it's a new law. A lot of jurisprudence is still to be developed.
But how do you do that? You develop jurisprudence by deciding upon the matters.
Correct.
You do not develop jurisprudence by waiting for somebody else to decide upon
sometimes,
the matter. You know?
Sometimes the time taken is because it's a new point of law, but so many times there is an avoidance also to decide a crucial matter. And I agree with you there.
Can I just add
Yes, please.
one point very quickly? I think the appointment criteria of judges on the NCLT needs to have a very, very serious relook. Because some of the criteria is just downright weird. And the second problem that I find day to day is that the function of the judicial member and the function of the technical member is not very clearly defined. Now the technical member is on the bench for a certain reason, because he or she adds expertise to the tribunal and the matters that are at hand before the tribunal. But we must remember that the technical member has never been a lawyer, or in most cases has never been a judicial member before any other forum. Therefore, basic things like writing a judgment, appreciating arguments, sometimes could be a challenge for them. And I'm not blaming them, but it's like putting a lawyer and asking him to do the job of a CA. We'll be at sea.
Correct.
But practically we find that in a lot of benches, the judicial member is silent and the technical member takes over.
Technical member takes over, yes.
And then there are, problems that follow with it. There are problems with judgments written, the reasoning of judgments, which are susceptible ultimately in challenges before the higher forums. I mean, this is just symptomatic. My larger point is that we really, really need to look at, not just in terms of retired High Court judges or retired Supreme Court judges being on the tribunals, but we need to look at the criteria of appointments to these tribunals as a whole. And very, very seriously that needs to be looked at.
Correct. Correct, I agree.
With the permission of the panel, if I may just intervene.
Yes, we are short of time, but short comment is
just a
welcome.
very brief sentence that, what we also need to do is discipline the entities which are involved in this entire matter. As I understand the original side practice, there are elaborate laws relating to impediment and intervention. In one of the IBC matters recently, Income Tax Department was not a party to the proceedings before the NCLT, but has now tried to intervene at the NCLT appellate stage. Now that needs to be disciplined.
Correct.
Just a good thought on that is that when it comes to merger proceedings before the NCLT, they have to pass the first motion order within 30 days of reserving the order.
Right.
So something like that can easily be put into the IB code. If they can discipline themselves for mergers, they can discipline themselves for the IB code, and hopefully then company law matters can be heard because they get no chance for that.
That can be done. Coming to Ramakrishnan sir, this is the end of the session. In my practice, I have had very few instances where I have been asking questions from the senior advocates. Otherwise, they have been asking questions from me as a briefing counsel. So I'm enjoying this opportunity. But no more, sir. I have nothing to ask you. Any closing remarks for you, for us, for all of us, with your experience, are most welcome.
You have heard the opportunities and the challenges of IBC. I want you to carry two images in your mind. Now, we have read about celebrity deaths. Celebrities with huge biceps, abs to die for, that kind of celebrities working out in a gym. Cardiac arrest, sudden death. This is one image. Second image is, tomorrow you have a huge opportunity. Somebody says there's a marathon in your neighborhood. You don't have to win the marathon. Just participate, you'll have crores of rupees coming in. This is an opportunity. There you must remember the first man who ran the marathon in Greece, he died at the end of it. So what is the takeaway for you as law firms and general counsel is you need to prepare your client for these pitfalls, challenges and opportunities. Now, the businessman typically looks at turnover, looks at bottom line, and he looks at valuation. So he gets onto this biceps, abs, and then you have a sudden death of liquidity, insolvency coming in. Similarly, you have, as Manisha pointed out, huge opportunities for purchase, but you don't have the wherewithal, that goes into death again. So you need to, I think, as general counsel and law firms, you need to start living with your clients, more closer interaction. You can't be a surgeon in the emergency ward anymore. You need to be a life coach. You need to be a general practitioner, warn them ahead, have a 2-year horizon which you are qualified to give them. The businessman won't have that kind of a horizon because he's had today's opportunities and today's problem.
Correct.
That I think is the takeaway from this discussion. Your role as counsel is much more modulated and much more challenging, evolving.
Thanks a lot, sir. That was an excellent summation. Any questions if we have? Otherwise, we'll take your leave and leave you for the other panels. Thank you very much. Thanks a lot. Thank you.